Check out carmarshal.com. The link is in the description. They help support us.
Morning Mix. Barbarism. Texas judge ordered electric shocks to silence man on trial. Conviction thrown out. By Megan Flynn, March 7. Email the author. In Tarrant County, Texas, defendants are sometimes strapped with a stun belt around their legs. The devices are used to deliver a shock in the event the person gets violent or attempts to escape. But in the case of Terry Lee Morris, the device was used as punishment for refusing to answer a judge's questions properly during his 2016 trial on charges of soliciting sexual performance from a 15-year-old girl, according to an appeals court. In fact, the judge shocked Morris 3 times, sending thousands of volts coursing through his body. It scared him so much that Morris never returned for the remainder of his trial and almost all of his sentencing hearing. The action stunned the Texas 8th Court of Appeals in El Paso, too. It has now thrown out Morris's conviction on the grounds that the shocks ordered by State District Judge George Gallagher, and Morris's subsequent removal from the courtroom, violated his constitutional rights. Since he was too scared to come back to the courtroom, the court held that the shocks effectively barred him from attending his own trial, in violation of the Constitution's Sixth Amendment, which guarantees a defendant's right to be present and confront witnesses during a trial. The ruling, handed down February 28, was reported Tuesday in the Texas Lawyer. Judges are not allowed to shock defendants in their courtrooms just because they won't answer questions, the court said, or because they fail to follow the court's rules of decorum. While the trial court's frustration with an obstreperous defendant is understandable, the judge's disproportionate response is not. We do not believe that trial judges can use stun belts to enforce decorum, Justice Yvonne T. Rodriguez said of Gallagher's actions in the court's opinion. A stun belt is a device meant to ensure physical safety. It is not an operant conditioning collar meant to punish a defendant until he obeys a judge's whim. This court cannot sit idly by and say nothing when a judge turns a court of law into a Skinner box, electrocuting a defendant until he provides the judge with behavior he likes. The stun belt works in some ways like a shock collar used to train dogs. Activated by a button on a remote control, the stun belt delivers an 8-second, 50,000-volt shock to the person wearing it, which immobilizes him so that bailiffs can swiftly neutralize any security threats. When activated, the stun belt can cause the person to seize, suffer heart irregularities, urinate or defecate and suffer possibly crippling anxiety as a result of fear of the shocks. The stun belt can also be very painful. When Montgomery County, MD, purchased 3 of the devices in 1998, a sheriff's sergeant who was jolted as part of his training described the feeling to the Washington Post like this: "If you had 9-inch nails and you tried to rip my sides out and then you put a heat lamp on me." Most courts have found that the stun belts are constitutional as long as they are used on defendants posing legitimate security threats, but the Texas justices said there was no evidence of that here. The discord between Morris and Gallagher arose after Gallagher asked Morris how he would plead, guilty or not guilty. "Sir, before I say that, I have the right to make a defense," Morris responded. He had recently filed a federal lawsuit against his defense attorney and against Gallagher, whom he wanted recused from the case. As Morris continued talking, Gallagher warned him to stop making outbursts. "Mr. Morris, I am giving you one warning," Gallagher said outside the presence of the jury, according to the appeals court. "You will not make any additional outbursts like that, because 2 things will happen. Number 1, I will either remove you from the courtroom or I will use the shock belt on you." "All right, sir," Morris said. The judge continued, "Now, are you going to follow the rules?" "Sir, I've asked you to recuse yourself," said Morris. Gallagher asked again, "Are you going to follow the rules?" "I have a lawsuit pending against you," responded Morris. "Hit him," Gallagher said to the bailiff. The bailiff pressed the button that shocks Morris, and then Gallagher asked him again whether he is going to behave. Morris told Gallagher he had a history of mental illness. "Hit him again," the judge ordered. Morris protested that he was being tortured just for seeking the recusal. Gallagher asked the bailiff, "Would you hit him again?" Morris's trial defense attorney, Bill Ray, told Texas lawyer he didn't object to use of stun belt during trial because his client was acting like a loaded cannon ready to go off. He also claimed he did not believe Morris was really being shocked. As the Texas justices note, case law on the use of stun belts on defendants in court is slim, if only because outrageous uses of stun belts in courts are rare. In the several cases cited in the ruling, the stun belt's damaging effects on a person as well as their controversial history are well recognized. The stun belts were introduced in the early 1990s as a way to control prisoners. According to testimony in a stun belt case from the U.S. Court of Appeals for the 11th Circuit, the devices acted more as a deterrent rather than a means of actual punishment because of the tremendous amount of anxiety that results from wearing a belt that packs a 50,000 volt to 70,000 volt punch. Never before have we seen any behavior like this, nor do we hope to ever see such behavior again, Rodriguez wrote of Gallagher's actions. As the circumstances of this case perfectly illustrate, the potential for abuse in the absence of an explicit prohibition on non-security use of stun belts exists and must be deterred. We must speak out against it, lest we allow practices like these to affront the very dignity of the proceedings we seek to protect and lead our courts to drift from justice into barbarism. The judge, contacted by the Post, declined to comment, citing judicial ethics. More from Morning Mix. Cecil the lion suffered incredible cruelty for at least 10 hours, new book says. ICE releases mother it detained for months far away from 7-year-old daughter. Hate your selfie? There may be a good reason, says new study.
County, this is Charlotte County Cop Watch, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it, 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt-free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. You know, 47,000 of you so far right now. You know, $1 a day. I mean, $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.